All right, y'all, buckle up, because this one goes from calm to chaotic real quick. We got Shayna Blackshire, a self-represented defendant facing a stack of felonies, pushing every limit you could imagine. The judge is trying to keep order, the prosecutor's fed up, and Shayna, well, she's on her own planet today. This is one of those cases where every minute the tension climbs higher. Interruptions, confusion, attitude, and a whole lot of legal heat coming her way. Let's get into it, without spoiling how wild this ending
The date and
gets.
time set for sentencing. The records show the presence of the defendant. Our advisory counsel is here. And Mr. Wagner, are you appearing before the state?
Yes.
This is the time set for sentencing.
Excuse me, how you doing?
I'm talking now. Is your true name and your complete name Shayna Marie Blackshire?
The court lacks jurisdiction over the subject matter.
What is your date of birth?
The court lacks jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacks jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209. Count 1, unlawful flight from a law enforcement vehicle, a Class 5 felony. This is in violation of ARS 28624C. ARS.
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622, ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801. The date of the offense was on or about February 5th, 2022. The offense is non-dangerous, and I'm finding it non-repetitive for reasons I'll state on the record. Count three, that she is guilty of count 3, criminal damage, a Class 1 misdemeanor. It's in violation of ARS 13-1602A1, 13-1601, 13-707, 13-802.
She's jumping in every time the judge speaks, like she thinks she's running the courtroom. The judge's patience is already cracking. Why is she pushing this early in sentencing?
Ms. Blackshire, I believe that these are repetitive and that she should be subject to the Category 2 repetitive offender statute. She committed these crimes. She was taken into custody for the first crimes, the 208, Your Honor. She was taken into custody for 208. She made bond and was released on bond, and then she committed these separate offenses while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to...
All right, thank you.
If there was any confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was something to clarify up front.
I believe that it's more than warranted. She was sentenced. Those were separate cases. She was released from those cases, and she committed the new case. Not only did she commit these crimes separately from the other crimes, these crimes significantly, especially the burglary, I believe substantially affected the victim, the owner of the property at Morningstar Ranch. Yes, she was burglarized before. No real property was taken from there. As you heard, you sat through both trials. But in this case, in this burglary here, count 4, Your Honor, the defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge that.
She interrupts again right when the state starts talking enhancements. Her timing is wild. Every moment gets more tense. Is she trying to help herself or make things worse?
All right, defendant is back. You may continue, Mr. Wagner.
Thank you, Your Honor. I would also point out to the court that count 1, the unlawful flight from law enforcement, and count 5, the resisting arrest counts, are not in any way connected with the prior the 208 case. They're separate victims there. These are definitely separate incidents. The state would argue that as well for count 4, the burglary, Your Honor.
No, I'm not relaxing up in the legal. The court lacks jurisdiction over the subject matter. Y'all don't have no right. Get this shit off of me.
If I could have just a second, Your Honor.
What's the statutory reference to the 2-year enhancement? I can't remember that.
It is, I'm sorry, Your Honor, it is 708D, and I don't know that I made that entirely clear, but it just, whatever the sentence, the court prescribes each sentence gets a 2-year enhancement.
Is that ARS 13-707?
Yes, I'm sorry, ARS 13-708.
She starts reacting as deputies move her, and you can feel the energy flip instantly. The judge is clearly over it. Does she realize how bad
And more
this looks?
emotional stress to the victim, the owner of the property, and then we have separate victims as to the resisting arrest charge and the fleeing from law enforcement charge, Your Honor. I don't have anything more to add than that, and there's no victim's presence. There's some representatives, some neighbors, some people from the Morningstar Ranch that are still living in the area. They're present here today just to watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count 1, unlawful flight, a Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release, and that's pursuant to ARS 13-708D. So the total sentence as to count 1, Class 5 felony, is 3.5 years. As to count 2, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count 4, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the second degree, Class 3 felony. The court imposes the presumptive term of 3.5 years. This court also imposes the sentencing enhancement pursuant to 13-708D of 2 years. So the total offense level, the total sentence for count 4 is 5.5 years. As to count 5, resisting arrest, it's a Class 6 felony, non-dangerous, non-repetitive. The court imposes the presumptive sentence of 1 year. The court further imposes the sentencing enhancement as required by law under ARS 13-708D for 2 years for a total of 3 years as to count 5.
When the state lists aggravators, she stays quiet for once, but that silence feels heavy. Reality's hitting her hard. Is this the moment she finally understands the consequences?
To run consecutive to the sentence imposed on count 4, which was 5.5 years as to burglary in the second degree. So the sentence imposed on counts 1 and 5 is to run consecutive to count 4. The court imposes sentence imposed on count 4 in this case, which is burglary in the second degree of 5.5 years, is to run consecutive to the sentence that was imposed in case number CR 22208. Right, so the sentence imposed as to count 4 in this particular case is to run consecutive to the sentence imposed in case number CR 22208. That's because this defendant was released in the prior case, 22208, when it was a justice court case. She was released when she posted bond on July 7th, 2021. She failed to appear and a warrant was issued for your arrest on October 20th, 2021. The events in this particular case are alleged to have occurred, I believe, on February 5th, 2022. So the events that happened at the Morningstar Ranch that were the subject of 22208 are alleged to have occurred on the dates. Those were alleged to have occurred back on June 12th, 2021. So the prior case, the burglary, alleged to have occurred on June 12, 2021. The fraudulent schemes in 22208 was alleged to have occurred on or about July 6th. She was found guilty of that by the jury. So she was charged with that case, released, went out and committed basically new offenses relating to the same properties. For those reasons, the court runs the sentence on count 4 consecutive to the sentence imposed.
The judge breaks down her missed court dates and new offenses while on release. That's the nail in the coffin. Did she really think the court would overlook all this?
Well, I'm not going to ask you whether you wish to address the court. You've clearly indicated you're not capable of doing that and following the rules of the court. You have the right to appeal the judgment of the court. If you wish to appeal, you must file a written notice of your intent to appeal, and you must do that within 15 days of today's date. Otherwise, you will lose that right. Ms. Blackshire, do you wish the court to appoint an attorney to represent you on the appeal? No, he will not be representing you on the appeal. Do you wish to have an attorney appointed to represent you on the appeal? If you cannot afford to pay one, the court will pay the costs of an attorney to represent you on appeal. That will include the costs of the lawyer's legal fees and legal costs. You will not have to pay anything. Do you wish to have an attorney appointed to represent you on the appeal? No. Appeals are specialized actions, and they're Court of Appeals is very sticky with their rules. They're very strict, and this is a real specialty with someone who knows how to write good appeals. I met with you before when you were here before, and we met not in chambers, but in the holding cell area. It's all on the record, what I'm referring to, and I advised you that it really is in your best interest, I believe, to have a lawyer represent you on appeal, and you indicated at that time that you don't want a lawyer to represent you on appeal. I'd really encourage you to do it. I think it's in your best interest, but it's your choice. You're excused. You're remanded to the custody of the sheriff to be delivered to the Arizona Department of Corrections to fulfill a sentence. Hold on a second. What? Yeah, you can take them. You're excused. Thank you. Good luck. All right. I'm not having the defendant step forward to sign for notification of her rights and to sign the judgment in this particular case. She's consistently throughout all the proceedings in the Justice Court and in this court.
Even at the end, she's refusing to sign anything. The judge's patience is done. This is pure self-sabotage at this point. Why fight paperwork you can't avoid? This whole sentencing showed a defendant fighting every single step, while the court finally drew the line. Wild energy, non-stop tension, and a judge who refused to lose control. If this hit you the way it hit me, drop a comment and subscribe for more wild courtroom moments every week.